Welcome back to another episode of the Reminger Report Podcast on emerging technologies. I'm Zach Pyers, and I am happy to welcome back to the show Mackenzie Smith Compton to talk about the ABA this time and how it's addressing artificial intelligence in the application of law. Now, many of you may recall when Mackenzie was on the episode previously, she discussed kind of a broad scope of how the legal profession is addressing the use of artificial intelligence. And today we're going to be touching on kind of a more narrow topic that since the first episode was recorded, we now have a little bit of guidance from the American Bar Association as it starts to address the challenges presented by the application and use of artificial intelligence. So, Mackenzie, welcome back.
Yes, thank you so much for having me.
If you could kind of tell us, what is the ABA addressing in this most recent kind of pronouncement, so to speak?
Sure. So back in July on the 29th, the ABA released new guidelines for how attorneys should be dealing with the use of AI in their practices. So broadly, the opinion addresses the implementation and ethical considerations for using AI. It complies with the model rules of professional conduct, and it also takes into account regulations that about 12 other jurisdictions have set into motion. So it takes these very broad issues and it breaks them down into 5 distinct categories: competent legal representation, protecting client information, communication with clients, advancing meritorious claims, and reasonable attorney fees.
Okay, so let's kind of break those down. Let's start with the competent legal representation aspect of this that we discussed briefly in the last episode. What does the ABA have to say about how competent legal representation applies to the use of artificial intelligence?
So the ABA points to Model Rule 1.1 in its analysis, basically stating that attorneys have an obligation to provide competent legal representation to their clients, and this extends to the use of AI. So attorneys don't need to be experts on how to use AI, but if they're going to use AI in their practice, they need to understand the limitations, the benefits, and the applications of the products that they use. So, for example, if you're using ChatGPT, you need to understand whether or not the information is private. You need to understand if the information will be accurate. If you're using something like Lexis, then you need to understand the different applications that you can work with in the program to make sure that you're getting the most up-to-date legal research. So really, the ABA is focusing on an ongoing requirement to understand generative AI, and it's emphasizing that attorneys can't just pawn work off onto the AI. They still have to be involved in the analysis of the case.
The second category you mentioned of issues kind of that the ABA is addressing is protecting client information. So how does the ABA talk about that, and how does it address it in this most recent kind of guidance?
Sure. So this goes back to making sure that attorney-client information is kept confidential under Rules 1.6, 1.9C, and 1.18B. So basically, this is emphasizing that you need to understand if the searches that you're doing in AI are what is referred to in AI as a proprietary search. So basically, a proprietary search is one that's private, and the system isn't going to take the information that you input and then use it to inform its decisions and its information in queries that come from other people outside of your firm or outside of your practice. So this is really critical because if you're using AI to look at medical records and you input medical records into an AI generator and it's not a proprietary resource, your client's information is out in the ether. So it's very important to make sure that not only are you keeping that client information private, but you're understanding that the AI will do so as well.
Now, you also mentioned that client communication is an area of concern, which, obviously we do a lot of communications with clients via email nowadays and other forms of electronic communication. This is something we didn't previously discuss. So how is the model rules kind of applying to this area?
Sure. So the model rules are referring back to Rule 1.4, which requires that attorneys reasonably consult with their clients about the means by which the objectives of the case are to be accomplished. So the ABA is encouraging attorneys to be explicit with their clients about the use of AI. So if you're going to use AI for research, it's very important to disclose that to your client and let them know, hey, we've got this tool to use AI. We're going to use it in your case, so that they can say, I don't really want you to use AI in my case, or that sounds great. Sounds like it could save some time and money. So the main takeaway there is that you just have to disclose the use of AI to your clients, and they need to understand what your AI can do.
The ABA also addresses the supervising employees and agents. Now, what is the ABA trying to accomplish with this kind of aspect of their guidance?
So the ABA is really citing to rules 5.1 and 5.3, which impose upon attorneys the duty to supervise subordinate lawyers, paralegals, assistants, anyone who may be working in the office. So really there's two distinct groups here. We've got in-house people and people who are out of house. So thinking about our paralegals, our associates, other attorneys we work for, the ABA wants firms to establish guidelines up front for the entire firm and for anyone who might be using AI about how it should be used. And there's a reciprocal duty here for the attorneys monitoring to make sure that anyone doing work for them on a case is abiding by those rules and not using AI outside of the guidelines. Then turning to out-of-house resources, there's a duty for attorneys to make sure that any experts you might retain, anyone who might become involved on a case to review records, anyone who may be rendering an opinion, even a court reporter, understand how they're using AI and how that fits into the model rules and the ethical regulations.
Now, the fourth area that the ABA kind of provided guidance on discusses, and it relates to the advancing of meritorious claims and contentions to ensure candor toward the tribunal. Now, that's a lot of kind of jumble. What's the ABA trying to do with advancing meritorious claims and contentions while still ensuring candor towards the tribunal?
Yeah, so Zach, you and I actually talked about this at length during our last podcast. We talked about those attorneys up in New York, Schwartz and LaDuca, who we just love to cite to as a reason to not use AI in the practice. Really, this is dealing with the case hallucinations and hallucinated citations where ChatGPT is making up fake cases, fake case names, and attorneys are using those case names and using the citations and the law and briefs to the court, and they're getting caught. Basically, the duty of candor to tribunal means that we have to be honest with the court, and any information that we put in front of the court needs to be true and so that attorneys know that if you do use AI, you need to make sure that what's being put out is accurate. So basically, it's just encouraging shepherdizing and encouraging vigilance on these programs.
Now, can you tell me, one of the things that I think a lot of people have talked about is that the use of AI can make attorneys more efficient. The efficiency, right, in a model where oftentimes attorneys bill by the hour, sometimes decreases potential revenue for the attorney or decreases attorney's fees, which is more cost effective for the client, but also generates less revenue for the lawyer. Could you tell us how the ABA kind of addressing the use of artificial intelligence as it relates to attorney's fees?
So the ABA just wants to make sure that under Rule 1.5, fees are reasonable. So if you're going to employ ChatGPT or another AI resource like LexisNexis to do your legal research, if Lexis can accomplish the research in 15 minutes and that's what you use, you can bill 15 minutes for that. You can't go over. Now, if you have to shepherdize, that's another question where if you're shepherdizing and you're doing the active research, that's time that could be added on. But overall, you cannot charge more time for the use of AI than what you're putting into it. So the ABA is really just making sure that you're providing the right rate. Further, you cannot charge your clients for the time that it takes you to learn how to use the AI. So if you have to go to a seminar to learn how to use AI, or if you enroll in a course in a local community college or an institution to try to figure out how to use AI in your practice, you can't then pass the bill on to the client and say, hey, I attended this seminar, thanks for paying for it.
Now, if you could, because we talked about a lot, can you kind of tell me what some of the big takeaways are from this guidance that the ABA has provided?
So the ABA has indicated AI is here. It's not going anywhere. Every attorney needs to learn how to use it. So to that end, we need to understand the AI that is used. You need to understand all of the implications as an attorney for how that AI is going to retain information, how it's going to provide you with information, and what the limitations are. Second, you need to make sure that everyone that you work with in a firm structure understands the AI that is being used, and make sure that you understand how others are using AI so that you can appropriately monitor. Third, clients need to be kept up to date if AI is going to be used. That's something that should probably come up front. The ABA has made reference to engagement letters. So making sure that the client is either on board with the use of AI or that you know that they don't want you to use AI. And finally, just as a general rule for practice, making sure that the fees reflect the work done and you're not overbilling for the time that you have actually taken to do work if AI assists you.
Perfect. Mackenzie, I really appreciate you taking the time today to kind of give us this update, especially, now that we have the ABA guidance. So I appreciate your willingness to come back and to talk with us and to share these kind of updates.
Thank you so much for having me, Zach.